Hello and thanks for joining us on the program. I am Imoni Amarere. On December 2021, while many were generally focused on the Yuletide festivities, the Supreme Court of Nigeria delivered a landmark judgment which will most likely reverberate in both judicial and political circles for a long time to come. It was a ruling in a case involving Joseph Nwobike, Senior Advocate of Nigeria, versus the Federal Republic of Nigeria. The Supreme Court ruled that the Economic and Financial Crimes Commission, EFCC, has no authority to investigate and prosecute financial crimes committed in a state. The Apex Court held that the corruption cases the anti-graft agency can investigate and prosecute are those which involve the movement of cash from Nigeria to foreign countries, that is, illicit financial outflows, or what is commonly referred to as money laundering, and corruption cases which involve federal finances. Emphasis here is on federal finances. According to the Supreme Court, this is because the EFCC is a creation of a federal law. This ruling has been interpreted in some quarters to mean that the EFCC has no power to look into the finances of states. As such, if an official of a state steals money from that state, the EFCC cannot investigate and prosecute that official. The official can only be investigated and prosecuted by the Attorney General of the state or by the Nigerian police or any other agency that is covered by the criminal and penal codes or any other law. In essence, the Supreme Court reportedly nullified the provisions of Section 46 of the EFCC Amended Act 2004, which empowers the Commission to investigate and prosecute any form of corrupt malpractices, including those emanating from states. The Supreme Court held that the power of the EFCC are regulated by the Global Action Against Corruption as circumscribed by the United Nations Conventions to which Nigeria is a signatory. Now, by virtue of this ruling, it is being canvassed by some legal pundits that the EFCC can no longer go after real or suspected corrupt state officials, even in the face of glaring evidence. Some legal pundits have interpreted this ruling to mean that each state can now make its own law and establish its own anti-corruption agency to deal with corruption in those states. Some others, however, argue that such a step would be an unnecessary duplication of laws, since the states can draw on the criminal and penal codes which have provisions that deal with corruption. Besides, what is this likely to do to state judiciaries and the quick dispensation of justice, especially in states where the judicial arms are tied to the apron strings of the executive? What is the correct interpretation of the Supreme Court judgment? What are the wider implications of this ruling for anti-corruption fight in Nigeria? Now, to begin with, by the provisions of the Constitution 1999 as amended, state chief executives currently enjoy immunity from prosecution while they are in office. Does this decision not mean that they will be left to walk free from any financial atrocities that they commit while in power, even after they leave office? Does it also not mean that the EFCC can no longer pursue the several cases of corruption against former executives and contractors pending in various courts across the country? Can the police and state attorneys generals rise to the challenge that the Supreme Court has thrown at them to institute charges against culpable former top officials, especially elected officials of government? And does the ruling allow for states to invite or seek the assistance of the EFCC in conducting investigations into cases of corruption where they lack the means and the wherewithal to do so? Could the Supreme Court have dealt the unkindest of court yet on the fight against corruption in Nigeria, knowing that the states and their top-level executives are major centers and facilitators of corruption in the present democratic dispensation? Would the Supreme Court ruling not encourage and embolden more corruption, as state officials would most likely dig deeper into the coffers of their states? And politically, would this situation not make the jostle for power at the state level more atrocious and deadly? These and many more are the issues we shall seek to resolve on the program today. Join me and my team of analysts right after now. Let's get to meet our guest analysts. Two of them are right here in the studio, and another is joining us virtually via Zoom. First, from my immediate left is Mr. Tony Ogugwo. He's a legal practitioner based here in the nation's capital, Abuja, with interest in commercial and public law. Thank you so much for joining us, Mr. Ogugwo.
Good afternoon.
Also right here with us in the studio is Mr. Dakpo Otitoju, who is also an Abuja-based legal practitioner. Thank you, Mr. Otitoju, for joining us.
Thank you very much.
And joining us virtually via Zoom is Mr. Soji Apampa. Mr. Apampa is an anti-corruption activist. Mr. Apampa, thank you so much for finding time to join us.
Thank you very much.
Welcome. Thank you. So let me begin from right here in the studio. Let's get to the legal basis for our discussion. The judgment that is referred to is the appeal of convicting Joseph Nwobike son for bribery. And it is from this judgment that these issues have been thrown up. First and foremost, let us understand what this judgment was.
Yeah. Thank you very much. The judgment of the Supreme Court, like we all have read, and some who have decided to read journalistic review of it, is different from what is being peddled. What the judgment clearly states is the fact that the powers of the EFCC, as provided for by Section 46 of the EFCC Act, does not include certain positions, because the particular part which the EFCC relied upon to prosecute Joseph Nwobike is any other matter. Now, the Supreme Court, in interpreting that part, said any other matter will only include financial crime as it relates to Section 46, and not to any other crime as a crime of perverting the course of justice. Because a crime of perverting the course of justice is not inclusive, according to the decision of the Supreme Court. And before they arrive at that, the Supreme Court decided to use what we call the rule of Judgement generics. And then, as far as to also refer to Section 36(12) of the 1999 Constitution, that you cannot convict a person on a crime that has not been described. Any other matter. Now, in describing any other matter, it does not include perverting course of justice. Now, under Section 97(3), sub C, of the Administration of Criminal Justice Act in Lagos, it does not also define what perversing the course of justice means. And so, the Supreme Court, looking at all these provisions, found as a fact that indeed that section, even though the trial court judge even said that while he was handing down the judgment in Nwobike, that it was not properly described, that that section did not define the manner of perverting the course of justice. Now, it does not then mean that one can now say EFCC, who is only saddled with what's it called? Monetary, economic crimes.
Financial crimes.
Economic financial crime.
Yeah.
Should now then be dabbled into certain crime that could be investigated by the DPP and, of course, be prosecuted by the Attorney General. Now, that does not mean that it now translates that financial crime cannot be investigated by EFCC in states. That is not the intendment of that decision. So I don't understand where they got that provision. Because even Justice Tijani, JSC, while rounding over, and he was the one who gave the lead judgment, said that this interpretation is because of the peculiar situation. That let it not be said that they have interpreted Section 97.3. That what they have simply done...
97.3 of the Constitution.
Of the Criminal Act, Administration of Criminal Justice, of Lagos. That it is, they have to arrive at this decision because of the peculiar situation of Section 36(12) and Section 46, which defines the economic and financial crime. And then even queried that the prosecutor needed to have cross-appeal. Maybe if they had cross-appeal, maybe it would have been a different situation. However, that decision did not translate to whether a governor
to removing the powers of the EFCC
from prosecuting all the governorship or whoever is accused or alleged of any crime. Because IMB versus Tinubu, it is clear that they can investigate and prosecute. Meaning that even if you as a governor, you can be investigated. You can only be preserved from prosecution or bail after you leave the seat. EFCC has that power under Section 46 to investigate economic and financial crime of both state and federal, as far as Section 46 is concerned.
So your position, Mr. Titoju, is that there is a misrepresentation
of the judgment.
Of this judgment. Is that the correct situation?
Absolutely. That is my position. We must try to understand the history of the Nwobike case and the issues involved. Mind you that there were three main planks at the trial court. That of trying to give gratification to a public officer, that of perverting the course of justice, and that of giving false information to an officer of the EFCC. In the court of first instance, the first and third series set of charges, Nwobike was acquitted on those charges. But on the course of perverting the course of justice, he was convicted. It was appealed against and eventually got to the Supreme Court. And the Supreme Court carefully looked at Section 6, Section 7, Subsection 2, Section 13, Section 46 of the EFCC Act, elaborately. And the Lord Justice, who delivered the lead judgment, emphatically said that nothing removes the power of the EFCC to prosecute people or investigate people for financial and economic crimes under the EFCC Act or under any other acts. And indeed, the Supreme Court, I think, people should get a copy of the judgment, and read through properly. The Supreme Court, in looking at the issues involved, extensively analyzed the Section 46 of the EFCC Act. And in particular, where the Act in Section 46 talks of any other corrupt matters. And that is the issue. And the Supreme Court had to go back to the United Nations Convention of 2003, which is a precursor to the EFCC Establishment Act of 2004. And in fact, the statements and address of Kofi Annan, may he so rest in peace, who was then the Secretary General of the UN, about the financial crimes internationally and what they expect to achieve with the act. And it is the United Nations Convention Against Corruption of 2003 that is the basis of the EFCC Establishment Act of 2004 that we have today. And what is this? What does it seek to achieve? To combat financial and economic crimes, illicit money laundering, narcotics, and other issues. And if what the Supreme Court decided, you can, I think page 18 or thereabout of the judgment and page 24 is very explicit. And the Supreme Court said that in terms of any other corrupt matters, it does not mean that the EFCC will have the right to be chasing about every other person that is involved in any crime. No. But in as much as it involves financial and economic crimes, the EFCC have absolute power and rights to prosecute, investigate, and prosecute people, whether it be the states or whether it be a federal issue. Provided you look at, in fact, the Supreme Court emphasized that looking at the UN Convention Against Corruption, what does it seek to achieve? And that is why my other friend, brother here has talked about the Ius Dem Generis principle, which the Supreme Court resorted to in interpreting Section 46 of the EFCC Act. And it was very explicit, it is very explicit when you read the judgment, that in no way has the powers of the EFCC been removed, only that the chasing of shadows by EFCC has been called to order. If you have private issues, it is not a problem of the EFCC. The Supreme Court, in particular, tried to interpret whether trying to provide the cause of justice amounts to financial crime, as contended by the counsel to the respondents, who contended that trying to provide the cause of justice amounts to corrupt acts, which is financial and economic, and as such that it gives the EFCC the powers to investigate and prosecute the person. And the Supreme Court said, no, this is not it. You don't have that power to go about chasing over every corrupt matter. No, it's not your work. Your work is to focus on financial and economic crimes as it affects the funds of government, whether it be local government, whether it be the state government. The Supreme Court didn't, in fact, even go into elaborating whether it is state or federal. I am surprised actually to read some of the analysis of people saying that as a result of these judgments, that the state governors or past governors who are being tried by the EFCC can now go scot-free. No. That is not the from what I've read in the judgment, that is not the situation.
All right, Mr. Apampa, let's come to you. I'm sure that as an anti-corruption activist, when you read some of these reports in the media and analysis that were done, even by legal practitioners, you must have been, in a way, disturbed by the fact that the Supreme Court seemed, from those reports, I've obtained a copy of the judgment. I've read through it very painstakingly, and I tend to agree with the lawyers here that there is an over-exaggeration of some of the things said by the Supreme Court judges. Well, what would then be your immediate reaction to these to looking at the real content of this judgment?
Thank you very much. You know that at the end of the day, the judgment is only fuel for the fire. Many people would like to be able to shape public opinion and also shape the narrative. And many will also like to test the resolve of the EFCC as to whether or not the EFCC is still determined enough and confident enough to go with their existing prosecutions, whether they will go forward with it or not. I think that what people should be aware of, especially those who are peddling the position that it means that the EFCC cannot prosecute financial crimes anymore, is that even so, there's a whole raft of agencies and a raft of laws. You cannot escape. Just because you escape one agency doesn't mean you can escape all agencies. I remember at a time when it was rumored that Nuhu Ribadu will not be able to prosecute certain ex-governors. Well, the matter still ended up in the UK. It couldn't go very far. It was still prosecuted and convicted and served time in a UK jail. So at the end of the day, what people should realize is that the whole world is getting more activist on the issue of prosecuting corruption. So just because you misinterpret a law doesn't mean that that agency cannot go back to the courts and continue with the case. So I'm very glad about the clarifications that have been made, but some of us were not too perturbed by the ruling, by thinking that it means that all prosecutions will now have to come to an end. That is not true. And I'm glad that the analysis that we have also bears that out.
In other words, are you disturbed by the fact that there was a deliberate misinformation, a deliberate spin that was put to this ruling by the Supreme Court, supposedly by certain interested parties and individuals to mislead the public?
No, I think the disturbing thing is if those individuals did not try to defend themselves. I think that you will find a lot of it. I mean, where did fake news come from? It's from people who really want to muddy the waters, make it very difficult for people to be able to tell right from wrong and good from bad. That's why people do it. So it is clear that it will happen. And I think that all agencies, EFCC, ICPC, whoever is prosecuting has to be ready for that kind of misinformation and know that it's also a battle for the hearts and minds of the people, in addition to the battles that are taking place in the courtroom. Half of it is political. So you also have to be ready for that, because some of these characters would like to be able to put themselves up again for political office. And this is part of the process of laundering their image and confusing the public. So we really need the advocacy to continue and analysis on the media to continue the way that it is taking place.
All right, stay with us, Mr. Apampa. Let's get back to the lawyers here and let's get their view. There is a portion of that judgment where the Supreme Court justices seem to have talked about any other form of corrupt malpractices as contained in Section 46 of the EFCC Act as amended 2004.
Yes.
What is that provision talking about?
You see, that particular provision is what the EFCC hang on to say they have jurisdiction to prosecute Nwobike as a form of economic crime. I mean, corruption, which also, of course, give them the right to investigate it. That is what the Supreme Court interpreted, that no, that particular provision is subject to a Jusen generic interpretation rule. That means that you must interpret that particular provision along with the parents, the entire provision. What does it state? If you look at that section 46, it talks about certain crimes which were listed there. Financial, economic, financial crime, they were delineated there to include money laundering, to include there are various crimes. If you have it there, you can see that particular provision now must be interpreted along with section 46. Now, if you are now saying that is it, The crime you are now asking, you are convicting Nwobike for is perverting the cause of justice. Does it include perverting the cause of justice? Any matter, does it include perverting the cause of justice as a corruption in economic crime? That is what the Supreme Court interpreted, that it does not include it. And they went to the jurisprudential flavor, how economic and financial crime got their act, what motivated the provisions. And that's why he referred to the convention.
United Nations Conventions Against Corruption.
That brought about corruption and brought about the act, EFCC Act itself, Nigeria. What was the provisions? The Apex Court justices went on that. In fact, to vindicate their position and assert that no, this is part of the act that is worthy of applying the generic rule. To now find that EFCC should not dabble into things that are not mentioned in Section 46. What has not constituted economic crime, EFCC should not go into it. Tenancy matter, EFCC cannot be, going to arrest somebody for tenancy matter. Matters that are not within economic whatever should not be their problem. Concentrate on economic crimes. Economic crimes anywhere in Nigeria, you can go in.
Anywhere in Nigeria?
Anywhere in Nigeria.
Okay.
They have that jurisdiction to investigate and prosecute.
Okay. Well, Mr. Ogugwo, let me refer you to a section of, or a part of that judgment where it said, for instance, the judge said, for instance, that any form of corrupt malpractices used in Section 46 of the EFCC Establishment Act, if the literal meaning is adopted, it means that the powers of the EFCC will be at large and open-ended.
Exactly.
Because by that interpretation, every criminal and illicit activity committed will fall within the scope of corrupt malpractices and consequently be regarded as an economic and financial crime.
Exactly. That's what my colleague here tried to explain. In this aspect, the Supreme Court's justice was looking at the literal interpretation of Section 46. That if the courts were to adopt the literal interpretation of Section 46, it will make EFCC to be like a colossus, bestriding over the whole country, and every other agency or every other statute will find itself as a dishonorable grave under the colossus of which the EFCC would have turned to be. That is why the Supreme Court now have to rely on the ius generis principle. It is important to explain this so that a common person will understand. What did the Supreme Court do? The Supreme Court said, let us look at how we got about the EFCC Establishment Act. Let us look at what is that the legislature tried to achieve in enacting this law, and what we are intending to achieve. And when you look at it, you can only get the meaning from the context of the law. And you look at Section 46. Section 46 is very explicit, and it talks about violations of existing legislations, about money laundering, about financial crimes, and issues like that. And the words that follow it immediately after that about bribery, embezzlement, money laundering, blah, 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 looting, any form of corrupt practice. That is what the Supreme Court looked at. And the Supreme Court came to the conclusion that, look, we can only interpret this in line to meet these other terms that have been explained. Corruption, in terms of money laundering, embezzlement, fleecing of the public fund, and any things like that. So it is very clear. In fact, I am surprised that people are trying to read the unnecessary meaning into the judgment. If the Supreme Court were to have accepted the literal meaning which the EFCC wanted them to accept in this regard, it would have made the EFCC to be a general policeman. You go anywhere, any corrupt practice, if I have issues with you about finances, you come and the EFCC will come and clamp down on me. If somebody borrows money from another person, the EFCC will be called in. If a tenant is owing the landlord, the EFCC will be called in. And the Supreme Court, by this fantastic judgment have just tried to put a stop to that. EFCC, face your work on financial crimes and economic crimes, money laundering and such incidental matters. Don't go out looking for problems where it does not concern you. And I think it is just very clear, and the Supreme Court shied away from the literal interpretation of Section 46 and adopted the Judiciary rule, which to a very great extent brings a lot of sanity to fight against corruption and financial crimes in Nigeria. Because were it not that, of course, you would have seen the EFCC getting involved in every other matter. Everything conceivable under the sun, the EFCC has hand in it. It is not supposed to be, and that is why they're overburdened. So the Supreme Court has, in fact, helped Nigeria by coming out explicitly to say, look, your work from the act setting you up, from the United Nations Convention Against Corruption, from all the preambles to the United Nations Convention on Corruption, listed them out as the UN listed them out, and also cited Section 15 of that convention, which enables other countries to, other member countries to domesticate the law in their countries, and emphatically pointed out at the issue of public finance. Public finance. And in fact, that convention stated emphatically that one of the main purposes of the convention is to make sure that countries and states cooperate to return illicit assets stolen by politicians and other public officers from countries and ill-gotten wealth. In fact, reading through the judgment, I don't see where we can start reading meaning to say that maybe a governor, past governor, public officer, chairman of the local government or whatever is now free to decide. And moreover, like you said when you were starting the program, we state Ministry of Justice or Attorney General of a state can prosecute a governor. Truly saying, I mean, we know it's not possible the way the country is today that a sitting Attorney General or Minister of Justice in the state can really prosecute a past governor for any crime that relates to financial crime or economic crime in the state, as we know, is very basic in our society. I mean, we know what is happening. So the Supreme Court wouldn't have armed the politicians to fleece the country. No. The Supreme Court has in fact told the EFCC, concentrate on your work, do it well, and yes, only limitation. Do your work well, focus on it.
Don't estimate or bring or add to your functions.
To your functions. I mean,
the functions is clearly stated at that section 46. Now, you cannot, because what it means is ultra-vires powers. You know, in law, they say it is over ultra-vires, your power, to go and add what the law has not given to you. Now, for them prosecuting, for instance, dabbling into what police should investigate and prosecute, they have gone ultra-vires. Their powers and functions. So what they really did was to say, look, don't extend your powers to all these other areas that the Act has not provided for. And which is
was that what the Supreme Court judges meant when he said, and I quote, so doing we make a pygmy of other legislations and render them barren and sterile.
Yes.
This is certainly not the intention of the legislature necessitating the establishment of the EFCC and enacting the Act.
Exactly.
That is it.
You know, that's the continuation of the initial quotation from the judgment that you read.
That is it.
That is what the Supreme Court is seeking to avoid. A situation where the EFCC overburdens itself with unnecessary matters and thereby overlooking the core issues for which they are set up. Financial and economic crimes as it affects public funds.
No.
I don't see what the EFCC has to do with the fact that somebody has a contract with somebody and they have issues about money and stuff like that. I don't know where the EFCC comes in that. I don't know why the EFCC will go to people's houses in the dead of the night for private financial dealings.
So what it means, sir, is that contracts between two private Nigerians, it does not concern EFCC. What it then means also is tenancy agreement within landlord and tenant. It does not concern EFCC. What it means is that when there is stealing, it does not concern EFCC because stealing What it means is by what's it called? Police investigation.
Except, of course, it
It
has
comes
to do with
public funds.
And we have to understand.
Under the normal so-called
police investigation matters. And we have to understand, like, the Supreme Court tried to really go into details in looking at that issue of perverting the course of justice, trying to pervert the course of justice, and thoroughly dealt with it. And you know, the funny thing is at times when you read the judgment in part, you don't seem to get the beauty of the judgment. When you read the Supreme Court judgment in full, and you see how the Supreme Court dealt with this issue of attempting to provide the course of justice, and of course dealt with Section 97, Subsection 3 of the Criminal Law of Lagos State of 2011 and other issues, then you come to appreciate exactly what the Supreme Court has done. A lot of sanity in the system, and like the other aspect of Section 97, Subsection 3, the Supreme Court said that emphatically because of the facts of the case, because the respondent tried to cross appeal but couldn't cross appeal. The attempt to cross appeal failed at the Court of Appeal, and they lost that opportunity. Because maybe if they had cross appeal successfully, maybe the issue about Section 97, Subsection 3 would have been dealt with in a different way. But as in regards to the attempting to provide the course of justice, please, EFCC, you are not a minister interloper walking about the streets trying to fight every person that you think has done anything corruption. No. Can you please concentrate on Section 46 as provided in your enactment, Section 6, Section 7, Section 13, Section 14 to 18 also, that gives you the powers. Look, those things are very explicit. Can you please concentrate on them and do your work professionally and stop disturbing ordinary Nigerians in the normal course? The police is there to do their work.
All right, gentlemen, let's take a short break. Okay. And when we return, we will be going straight to Mr. Soja Pampa to at least tell us what the UN Convention and the relationship of the EFCC with the laws of setting it up and that convention have been over time. Have they been as active and as required by the law setting it up, the act setting it up since 2004 in carrying out its original and May function? All right, thank you for staying with us. Mr. Soja Pampa, let's come to you now. And let's have your take on the UN Convention, on the basis of which the EFCC itself was set up and the act establishing it was put in place. Here we've talked about the Supreme Court ruling saying, look, stay on your lane. Limit yourself to the core values of the law that set you up. Now, if you will look back over time, would you say that the EFCC has stayed the course?
Okay, sorry, I struggle a bit to hear your question very well, but my understanding of what you have said is that how well has EFCC performed on its mandate, which was derived from the UNCAC?
Very correct.
Do I understand that correctly?
Very correct.
Okay. Before I go to how well EFCC has done on UNCAC, just to mention that the implementation of UNCAC is actually a whole national assignment. There are so many things in the United Nations Convention Against Corruption which are broader than the EFCC Act. And every now and again, I think once every 2 years or so, there is a conference of state parties where they look at the progress in implementing the provisions of the UNCAC. So EFCC is just a small portion of what the UNCAC actually covers. Now to EFCC itself. You know, in the beginning of the life of EFCC, it was seen as an act that was set up to curb 419. And later on, when the Obasanjo administration was accused of using anti-corruption as a political tool, we remember in those days that there was a direction that EFCC was taking towards certain political figures, and especially the governors of states, to try to draw them on the straight and narrow. Now, that created another season in which the interpretation of the roles of the EFCC changed, particularly around 2015 and 2019. We saw also the emphasis that EFCC has itself given to its work, especially in relation to prosecution of those suspected of diverting public funds. So if you like, if you use the metric of how many prosecutions of these persons that EFCC has accused of diverting public funds has been attained, I think the record is less than desirable still at the moment, and that is from inception of EFCC. But there has been a lot more success when it comes to prosecution of those who are involved in advance fee fraud. So I think that a lot of this is also dependent on the level of political interference. At a time when, for example, we had Mrs. Waziri in charge of EFCC, she complained about senior advocates of Nigeria. She complained about the judges stalling and working against the EFCC's ability to secure these judgments. So I guess if you then take this ruling in the light of some of those complaints that have come out of EFCC itself, you will see that it appears as though there is an attempt from somewhere to limit the EFCC's effectiveness. But that is not true when you then get down to the analysis that we are listening to, that actually the EFCC is being reined in to focus on its core work of dealing with economic crimes. Economic crimes have not reduced in Nigeria. With each administration that has come, we have increased the number of people who are being accused, which means that if you take the economic crime as some kind of siphoning of water from the public system, and the faucet is broken, and EFCC is running after those who are fetching, then there's a problem in there because they seem not to be doing enough of the preventive work to stop more people doing what the predecessors have done. So we are left with just the area of how well they have prosecuted and sanctioned those who have erred, which I think is a faulty way. Therefore, it is good to call the EFCC's attention back to the fundamental job of reducing economic and financial crimes in Nigeria, which includes their prevention in the first place, which means more risk assessment, more mitigation of risks, more attempts to close off these things before they actually happen. So they would have to work, sadly, or maybe necessarily, with those who are in charge of the executive to ensure that there is more prevention that is being done. Otherwise, it is a never-ending activity that the EFCC is now dealing with. But I think it is welcome that they are being constrained to look at their core mandate and strengthen their ability to deliver on that.
All right, thank you, Mr. Pampa. let me come back to you, Mr. Tito. Do you think that this judgment, this ruling by the Supreme Court, would ultimately put the EFCC on its toes and like you said, go back to its core mandate of preventing economic crimes, financial crimes, and where they have occurred, pursue them with the vigor that is deserved. Because as you know, since it was set up, there are certain cases that have been in court since then and are unresolved.
That's true.
In fact, in some cases, investigations have not been concluded, talk much less of getting court judgments.
That's true. Well, by this decision of the Supreme Court, I believe that the chairman of the EFCC will call his team to order, especially the legal departments, who are saddled with this prosecutory aspect of the cases in the EFCC, because after the investigation, it is the legal department that will advise whether to prosecute the accused persons. So I believe that with this ruling, they will sit up, they will be able to stay within the confines of the law, which has been interpreted clearly to them. Section 46 is clear. It does not admit of any extraneous belief outside economic crime. So I believe that the chairman is very young, very energetic. He will pragmatically take the judgment as a point of sitting his team members together to get prepared for the core mandate of EFCC. The mandate of EFCC is clear, it's undiluted. It's unmistakably diluted by any means. So it is very clear to everybody. When you read it, you know it. Even as it is any other corrupt matter, is still affiliated to economic crime, public funds. That is why they are set up. So I believe the ruling will checkmate them and put them in proper sphere of how to deal with economic crimes and every other thing connected therewith.
Mr. Okugwo, well, where does the Federal Ministry of Justice come into this as a supervisory ministry to the EFCC?
Well, unfortunately for us, the Federal Ministry of Justice plays dual role, because the Attorney General is the Attorney General and Minister of Justice. Yeah. And that takes off the shine of being independent. You see, while listening to my colleague, I was just about saying that the Supreme Court decision alone cannot solve the problem. The political will has to be there. The EFCC, we know, is not operating optimally because it is saddled with a lot of political matters that makes it impossible for them to work. And the Ministry of Justice, I'm afraid, as presently constituted, cannot and will not be able to do much about the EFCC getting more efficient and effective in investigation and prosecution of matters. Remember that the EFCC on its own has powers to prosecute, investigate and prosecute. Yes, the Attorney General can always come in, but the Attorney General, like we have often seen in most of the cases, is more of a politician and does not play that role of Minister of Justice and Attorney General as independently as he should. I believe that if the Ministry of Justice is made to be as it should be, the voice from the Office of Attorney General and Minister of Justice, separate the two so that we become more professional, they become more professional in their work, then they can adequately supervise the EFCC to ensure that the EFCC stays within its confines. The problem is that, look, when you start dabbling into things that doesn't concern you, you're not going to be efficient. And that's the problem of EFCC. And the Federal Ministry of Justice, as presently constituted, I don't think will be in any position to do any good work in supervising them to be more efficient.
All right, Mr. Pampa, let's have your last word here. It's quite clear now that that judgment did not in any way remove the powers of the EFCC from investigating and prosecuting financial crimes and corrupt malpractices at any level, whether at the local government, state, or federal levels of government.
Yes, I think it's taking us back to the mandates issue. If you recall, every now and again, we come to a situation where people are asking, what is the mandate of the EFCC versus the mandate of the ICPC? Where do they overlap with the Code of Conduct Bureau? Every now and again, the issue comes up and then it dissolves again. Because if you look at the mandate of the ICPC, it is very clear. They have the power to prosecute corruption, to investigate and prosecute. They have the power also to prevent corruption. They also have the mandate to go out and inform the public and make sure that the public is properly enlightened. Now, in the case of the EFCC, are we to interpret their role as just being economic and financial crimes as it is there? And how do they interpret it? Is it just on the prosecution side or the prevention or the public engagement and enlightenment as well? There are many questions that we still need to debate publicly, because if we do not prevent, as I keep saying, then the work gets bigger and bigger, one administration after the other. We never close the gap. We just get worse and worse on corruption. We will see when tomorrow Transparency International releases the next installment of the Corruption Perception Index. Then we will know how far we have reached.
Thank you so much, Mr. Soji Apampa. He's an anti-corruption activist joining us all the way from Lagos via Zoom. Thank you for your time and for your contributions. All right, and here in the studio, we have been joined by Dakpo Otitoju, who is an Abuja-based legal practitioner. Thank you so much, Mr. Otitoju, for joining us at such short notice.
Thank you very much.
And Mr. Tony Ogugwo is a legal practitioner, also based here in the nation's capital. Of course, he is very interested in commercial and public law. Thank you so much, Mr. Ogugwo, for coming. That's our program for today. Thank you so much for investing your time with us. We'll see you again soon when we bring you a fresh edition of People, Politics, and Power. Bye for now.